All right, thanks so much for being with us here on Atlanta News First Plus. I'm Joy Lim Nakrin here with attorney Jamara Edward Shipp. Thank you so much for being with us.
Thank you for having me.
Okay, so I have in Mr. Shipp today to talk about a couple of the top stories that we're following. And the first thing that we want to talk about is some new precedent that has been set. And this is regarding rap videos being used as evidence at trial. And this is such an important issue because, of course, we've been covering the YSL trial where rap music has been admitted, lyrics have been admitted as evidence. Okay, so Jamara, we're talking about this case where essentially this murder conviction was overturned. A Georgia inmate was convicted 2 years ago of murdering a nightclub security guard, and the conviction was just overturned today because the highest court in the state of Georgia ruled that a rap music video showing him waving a handgun should not have been played for the jury. What's your big takeaway here with this case?
I think that it's very indicative of a shift by the Supreme Court in looking at, some of these extrinsic evidence that is being presented by some of these prosecutors regarding the guilt or innocence of some of these defendants. So just a quick recap, we have a video that shows that, this guy is brandishing a firearm in a music video, a rap video, and because of that, the Georgia Supreme Court found that it was more prejudicial, meaning that it was more harmful to his case than it was probative, which means that it was more harmful than giving information to the jurors. And I think that that's the right shift. Using this video, it only just kind of gave propensity evidence to the jurors to kind of paint this picture like, hey, this guy is known for using a gun, so therefore he has the propensity to use a firearm in murdering this security guard.
Yeah, and one of the things that we just want to make clear is that propensity evidence, is not admissible in court as a general rule, and propensity evidence, essentially just trying to explain for the viewers, is evidence meant to show, oh, well, this guy has a propensity to do this sort of behavior, violent behavior, let's say, or wave a gun around or whatever, and therefore he must be guilty in this particular instance. Is that right?
That is correct. One way that a lot of prosecutorial offices get by that is by using what is called a 404B motion, which just shows that a person has prior bad acts. And in theory, it's not supposed to be a propensity act or a way to show that this person has a propensity, but that's exactly what it does. However, in this case, they were just alleging that he had a gun in this video, and therefore that's how they were able to identify him. And they had so many other ways to identify this guy. So using this, 30-second clip of this guy brandishing a gun in a rap video clearly was beyond the bounds of whether it was actual relevant evidence or not.
Okay, so let's take it back to the YSL case, which I need to add is dark today, and court is essentially on a break, or I should say the jury's on a break, because the court is going to hear some different motions until court, the testimony resumes. But why is this so important, this finding by the state's highest court that, it was improper to use this music video?
So it's very important because YSL is basically a case about rappers choosing to rap, and the state alleges that they rapped about the crimes that they committed. The defense is saying that, no, these are not raps about the crimes that they committed. In fact, they didn't commit any crimes. These are just raps about what they witnessed day-to-day life, or even what they have seen growing up in that neighborhood. So by using these lyrics, using these videos, using all of these songs to try and paint this picture that YSL is a street gang by the district attorney's office, they're saying that all of this should be relevant and we should be able to introduce this. The Georgia Supreme Court has said, again, it can be admitted, but it has to be more probative than prejudicial. And I think that there is a great argument that many of the lyrics of YSL songs are more prejudicial than they are probative.
Yeah, I mean, and a lot of people definitely agree with you. And, one of the things that was interesting in this case is that the video was filmed in early 2019, and the murder happened months after that. So I just wonder how much the timeline might play in when we're looking at cases like YSL, if at all?
I think it's fact specific based on what the state is trying to do when they introduce these things. In that particular case, the one that was just overturned, the state was alleging that, hey, we needed to use this to identify the person. But there were multiple other ways to identify him. Nobody was saying that he wasn't there. I mean, I believe I read even the defendant acknowledged that he was there. So you have these acknowledgments of being on the scene, being at the scene of the crime, quote unquote, and then you introduce this evidence to say, oh, okay, well, this is how we identified him. It plays into, yeah, you're just doing this to try and say that he has a propensity to do these things.
Well, but here's one other question that I just thought of. I mean, the Judge Glanville for the YSL case already ruled that the lyrics would be admissible, and so we've already heard some of these lyrics be shared with the viewers, and I'm sorry, the jurors, I should say, and the viewers, because we stream it. But because of that, is it too late really for this particular case to have precedent, or is it something that would maybe, if anything, play a role on appeal, but not during the initial trial?
I think that it would play a great role on appeal. It's kind of too late to put the toothpaste back in the container at this point. I mean, the jurors have already heard it. I'm sure that there will be renewed motions for a mistrial based on this case law. But again, it's probably one of those things that they're going to have to take up on appeal. And depending on just how it was used, they might be successful on appeal if they get a guilty verdict.
Okay, I have another question for you, and this has to do with another case that we're following. So we're following the latest involving the investigation into Fulton County District Attorney Fani Willis, and I was just thinking to myself, investigation into Miss Willis. That's exactly what I think the goal may have been for former President Trump and his allies to kind of make that the headline, but it is the headline right now because there is an investigation into, whether she benefited from a romantic relationship that she had with a special prosecutor, Nathan Wade, who she appointed to help lead the investigation into the former president. So here's the newest development, which is that an attorney, Ashley Merchant, an attorney for one of the co-defendants of President Trump, former President Trump, Ashley Merchant, has now been subpoenaed to appear before the Georgia State Senate committee hearing tomorrow as they are investigating Miss Willis. So she's been subpoenaed, and this is important because we know that she was really one of the reasons that these allegations came to light, right?
Right.
It was a filing by her that actually brought to light these allegations of a romantic relationship between Miss Willis and Mr. Wade. Okay, so what do we expect in that hearing? What kind of questions do you think are going to be asked? How important is this going to be?
Okay, so what do we expect in the hearing? More political grandstanding. I'm very vocal about this, and I've been very adamant about it. I have no dog in this fight. I want it to be clear to your viewers out there. In fact, I work against the DA's office daily. So let's put that out there. The first thing that we have to pay attention to is this whole thing was a political move. You gaslight, you obstruct, you delay, you do all of these things to keep from looking at the evidence for what former President Trump is on trial for, along with his co-defendants, which is that quote-unquote perfect phone call in which he asked for those 11,000 votes. So we have the smoking gun to say that he asked for these votes, and he told the Secretary of State to find those votes for him so that he could win the state of Georgia and then go on to win the presidency, and the Secretary of State refused to do so. Now we have gotten into so far in the weeds that we are looking at the, I don't want to say extramarital because he asserts that the marriage was irretrievably broken at the time, but these affairs that Mr. Wade and District Attorney Willis had together. We have gotten so far away from the actual case that there is no other way to put it than it's just being a political quote-unquote witch hunt. So tomorrow you should expect to see the Georgia State Senators. The GOP does have a majority in the state of Georgia, so they are going to, make this a political thing and try to do whatever they can to try and delay this case. It's already going to be delayed at this point because we've had to go through about 2 to 3 weeks of this sideshow. So there's a high probability that the August date of this trial is not going to happen. This just adds to it.
Yeah, I mean, it's really interesting. You know, now the focus is a completely different investigation. Like you said, it's gotten so far away from where we all began, which is Miss Willis and Mr. Wade investigating the former president for alleged election interference, and, you know, his co-defendants for alleged election interference. And now she's being investigated, and Mr. Wade's being investigated. So I guess that was sort of, you know, if the goal was to delay and distract, it seems to have been accomplished in that regard. But I guess we'll just have to see. We're expecting a decision in the next couple of weeks here as to whether Ms. Willis and potentially Mr. Wade would be disqualified from actually hearing, you know, or prosecuting the case, I should say. Do you think that they will be disqualified?
Here's my thoughts on that. If a pro se defendant filed this, pro se being a person on their own, filed this same motion to the court, to the clerk's office, they would have been laughed out of the courtroom. So this whole thing, I don't see how any of it could lead to the disqualification of District Attorney Willis and her office. We have to remember that all of these allegations were made. It was supposed to be the smoking gun. There was supposed to be this testimony that would definitely show that there was a relationship beforehand. And it all was nothing. I mean, it fizzled out quickly. There were no affidavits written. There was no verification of the filing. There was nothing there. And yet we're still here waiting 2 weeks on whether or not we're going to have a trial. So, yeah, I don't see her being disqualified in the interests of justice, but I've seen stranger things, so I guess we got to wait.
All right. Any final thoughts on either of these cases before we let you go?
Yeah. The only final thought I have is, you know, I do commend all of the parties, especially Judge McAfee, in dealing with this. I know that this is a lot for him to deal with and his office to deal with. I know that Judge Glanville is dealing with a lot, especially with this new case law coming out. So, you know, big kudos to them and their staff, and hopefully they'll be able to move these trials along and, you know, keep everything going smoothly.
Definitely. And again, we do appreciate you coming in. If any of our viewers want to reach out to you, maybe they are looking for legal representation, can you just explain what kind of cases that you can help with and how to reach you? Okay,
so I am J. Edward Shipp. You can reach me on Facebook at Jamara Edward Shipp. You can reach me on Instagram at J, letter J, SHIPPLAW, J Shipp Law. You know, I'm not hard to find. I do criminal defense. I do personal injury. So reach out to me.
All right. Well, thank you so much, Attorney J. Edward Shipp, for joining us. And like I mentioned to our viewers before, you know, we're, of course, giving you gavel-to-gavel coverage of the YSL trial. It is dark right now, but we're going to resume our coverage when the testimony resumes. And we also, again, like I mentioned to you, we are awaiting in the a decision on the disqualification, whether Ms. Willis will be disqualified from hearing, or rather from prosecuting the case against the former president and his allies. We are awaiting a decision here in the next couple of weeks, so stay with us here on Atlanta News First. And if you haven't yet done so, we encourage you to download our free Atlanta News First mobile news app so you can get updates sent right to your phone. Thanks for joining us.